Very well.
Good morning, everyone. Welcome to today's class. I'm your facilitator, Fumi Yohana. Today we'll be looking at business law, registration of business and compliance requirements. That is today's module. So uh, let's quickly look at the objectives of today's module. What do we want participants to learn today? And participants to have basic understanding of the nature of the legal system in Nigeria to enable participants to understand the legal regime and regulatory agencies regulating businesses in Nigeria, for participants to know the types of business organizations and steps in the formation and registration of business in Nigeria, understand the basic nature and elements in a commercial contracts. So these are the objectives of today's module. By the time we are done with today's class, I expect participants to be able to know these things. And as we are discussing, you get to know why you need to know some of these things we are discussing. So what are the topics we are going to look at today? The topics are the Nigerian legal system. We are going to look at the Nigerian legal system. relevant government agency, uh, relevant government agencies regulating businesses in Nigeria, types of business organizations, and the legal implication of the various types of business organization, registration of business organization, and law of contract. So once we look at these topics, we get to have by by the end of today's class, you get to know the objectives we outlined. You get to know all these things, and when you are asked any question on it, you should. I don't expect you to know everything, but you should have an idea of what the Nigerian legal system, what the relevant government agencies regulating businesses in Nigeria are, and their functions, types of business organization, and their legal implication. As once we're done with this, you get to know what type of business organizations you need to register. If you're already you have a business on ground, then registration of business organization how would you register the businesses you are running? Is it you want to register it as a company partnership, or sorry, you want to register it as a company or a business name with the CAC. So by the time we are done with today's module, so let's look at the Nigerian legal system. So when we talk of the Nigerian legal system, we're talking about the totality of laws. We're talking about the totality of laws, legal rules, and everything that is obtainable within Nigeria as a sovereign country. So, if we say totality of laws, it comprises of all the laws that can be found in Nigeria, then the mechanisms that are used in enforcing the law. So when we are talking of Nigerian legal system, just look at it this way: we are talking about the constitution, which is the ground norm, then other laws that were gotten as a result of the provisions in the Constitution of Nigeria, 1999, laws like Kama, laws like the criminal code, the penal code, uh, laws like different acts we have in the countries. All these are part of the Nigerian legal system. Then we have uh, the executive. Sorry, we have the judiciary, which interprets the law, and the courts. Then we have the various agencies of the executive, which are responsible for implementing such interpretation by courts. They also form part of the Nigerian legal system. So when every time you think of the Nigerian legal system, think of the Nigerian uh, think of everything concerning making an implementation of law in Nigeria. It even comprises of the the legislative arm of government, because they also form part of that architecture. So let's quickly look at the meaning of law. What is then law? Definitely, there is no universal definition of law, but to a lawyer and the law profession, and for this course, we are more interested in the narrow and guarded meaning of law for this model as a rule of human conduct, that's tacitly or formally accepted by people as binding and backed up by some mechanism for sustenance of its binding nature. So one, it must be a rule to regulate human conduct. For something to be regarded as law, it must be also be formally accepted by the people. Then it must be backed up by some mechanism. Example is the Constitution of Nigeria is an example of law that we as Nigerians formally accepted that it should guide how we run our country. And aside that, it's backed up by some mechanism for its sustenance. What are those mechanisms? We have the executive, we have the legislature, we have the judiciary. So these are the mechanisms put in place to ensure that this constitution is being implemented in Nigeria and is sustained. So that's why we have the executive are playing their part. Executive, when we talk of the executive, don't just limit yourself to the president and his cabinet. Comprises of all government ministries, agencies, parastatals, whatever, they are part of the executives because they are the ones that implement whatever policy this the executive arm of government has. Then we have the legislative arm of government. Then we have the judiciary, which also plays a major part. Then what are the sources of these Nigerian laws? These laws do not fall from the sky. We must have gotten them from somewhere. So what are the sources of the Nigerian law? So first, we have the common law and doctrine of equity. The common law and the doctrine of equity are collectively referred to as the Receipt English law. When we say the Receipt English law, as the name implies, we got them from England back then when we were being colonized by England. They brought in their law, and we have now accepted them, and we have made them to be part of our law. For instance, the common law is a law based on the customs and traditions of people of the realm back then in England that was administered by the common law courts. So you see, these were administered by the old common law courts in England. So when they came to Nigeria, they brought such laws for us. And it's based on the customs and tradition of the people of England back then. Because how common law came about is as a result of the crown back then in England before the Norman conquest. Okay, I think after the Norman conquest, that the crown will send out itinerant justices. When I say itinerant, justices that are not in one place, they move from one place to another to go and administer justice based on the customs and traditions of the people. So it's based on the customs and traditions of the people that each itinerant judge will administer justice. So if he goes to a particular locality, he will administer justice based on the custom and traditions of the people of that particular locality. So it's synonymous to our own customary law, to the common law. Then if they administer justice in various communities, they will come back to the crown. They will sit down and look at the laws they encountered in the course of their administration. Those laws that are positive, those laws that are good, they will say, okay, I went to this particular community, I encountered this law, and this law is very good. I think we should make use of this law. I went to that other community, other justices will say, okay, I went to this community, this is how they administer this particular law when it comes to this particular situation. So in all other communities, because this law in this community is fair, it dispenses justice properly, then we should administer it in all other communities. So that was how the common law in England came to be. However, subsequently, the common law became more concerned about form and procedure rather than administering justice. When I say it became more concerned about form and procedure, all I'm saying is that rather than looking at the merit of the case, if common law says before you initiate an action in common law court, it must be in writing, and the writing must be in Times New Roman. So if you fail to put the writing in Times New Roman, a common law court will not entertain your matter because you fail to adhere to the procedure they gave you, which is to put the procedure in Times, to type your writ in Times New Roman. So if you fail to type it in Times New Roman, common law will say no, they will not entertain the case based on the fact that you failed to follow the procedure. So people became dissatisfied with what was going on with common law. So they began to petition the crown. So petition the crown, and the crown then comprises of the King's Council. And the King's Council back then comprises of the Chancellor and other people. And the Chancellor had a priestly background. And based on his priestly background, when litigants petition him from common law courts, he administers justice based on his priestly background. So as a result, litigants became dissatisfied with what they were getting at common law court. So they began petitioning the crown. So when they began petitioning the crown, and the King's Council will entertain such matters. So as a result, evolved the doctrine of equity. And doctrine of equity does not mean fairness in the literal sense. Rather, these are laws that are developed by the Court of Chancery for the purpose of mitigating the harshness of common law. So this time, as I used the example, common law will tell you your rate must be in Times New Roman. If not, they will not entertain your matter. So if you go if you petition the crown will look at the merit of the case. Is it because you failed to put to write down your rate in Times New Roman? Is that why the common law court doesn't want to entertain your matter? The crown will say no, 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 no. They will entertain that matter for you. So that is uh, doctrine of equity, mitigating the harshness of common law. So as a result, we in Nigeria have imbibed the provisions of common law and doctrine of equity to form part of our law. We have what we also call the Statute of General Application, where laws from 1990 upward are applicable to Nigeria. Those ones after 1990 would not be applicable to Nigeria because these are laws that were formulated in England. So we still imbibe these laws. So these laws also form part of the Nigerian law. Then we have the Nigerian legislation. When we talk of the Nigerian legislation, these are bills that are eventually passed into law when assented to by the president. We know that it's common that if there's a bill, the House of National Assembly or a state house of assembly will sit on that particular bill. They will deliberate and pass it into law. So uh, it's for the president to assent to it to be formally recognized as law. So, for instance, we have laws like the recently passed Companies and Allied Matters Act, and we have some bills that have already been passed by the National Assembly, like the uh, Finance Bill of 2020, which, if signed by the president, will become an act. So we these are examples of legislation that are passed by the National Assembly. We have a lot other legislation that have been passed by the National Assembly, and they are now part of our laws. Then we have the customary law. As I said, the customary law is also equivalent to common law back in England. These are body of rules and regulation based on the customs and traditions of the people of in a particular settings. So if you go to a particular setting, it's normal for you to see them. They have their own customs, the way they do their things. If somebody is dead, this is how they will go about. If burying him, sharing his properties, and the rest. So if that these customs were not after the coming of the colonial masters, these customs were not abolished. They still form part of our laws and are still applicable presently in our courts. That is why we still have customary courts and we have area courts, customary courts in the south, area courts in the north, for them to administer such customs. And this customary law, they are still effective. For instance, a notorious customary law is the Benin customary law of inheritance, where the first son will inherit the property in which the father was living in at the time of his death. And a popular case is the Idehen versus Idehen case. That case is a notorious case. So whatever any matter when it comes to customary law and it relates to Benin customary law and it has to do with inheritance, once you cite that case in any court in Nigeria, it becomes that's the law because that particular custom has become notorious and is recognized in Nigeria. Then we have what we call the judicial precedent. When I say judicial precedent is and case laws. Courts do not make law, the judiciary do not make law, but rather they interpret laws. So in the course of interpretation of laws, they make laws. That is why it's common for you to hear lawyers citing the case of so and so person, the Supreme Court decided. So the Supreme Court being the apex court of the land, anything the Supreme Court decides becomes a law. They will start a matter from a particular court, then they will appeal to the Court of Appeal, then it gets to the Supreme Court. So the decision of the Supreme Court on any matter becomes the law. Let's say, for instance, a law is saying Section 20 of a particular act in Nigeria is saying anytime you are traveling, you should put your product in the car. Then one lawyer came with an argument that in the car, it means it should be in the boot, not in the back seat. So if that matter goes to Supreme Court after it has gone to High Court, Court of Appeal, it goes to Supreme Court. Then the Supreme Court will look at that particular section and say, okay, from all interpretation, it means it should be in the boot. You should put that in the boot of the car. So if there is any similar situation or car or circumstances that arises that is similar to the one that has been already decided, that has already been decided by the Supreme Court, that is the way other courts will interpret it, that that particular thing should be put in the boot, not inside the back seat of the car. So that is judicial precedent and case law. Then we have what we call the international law. The international law are laws that govern relationship between countries, different states of land. So these laws also form part of our laws. For instance, we have treaties, we have customs and conventions. Some of these customs and conventions we've also domesticated, because the Constitution of Nigeria says that for any international law to be applicable in Nigeria, it must be domesticated. Domestication means that it must pass first, second reading by the National Assembly, then assented to by the President, then it becomes a law. And we also, if you check our Constitution, like the Chapter 4 of our Constitution, you see is we just imbibed the provisions of the United Nations Declaration on Human Rights and the African Charter on Human Rights. And in applying for fundamental rights in court, we still cite the African Charter. So this is to show you that these are sources of these international laws also form part of our laws. Then we have the hierarchy of Nigerian courts. We have the Supreme Court, as I said earlier, as the Supreme Court of the land, is the apex court of the land. Whatever is decided by the Supreme Court becomes the law. We have the Court of Appeal. The Court of Appeal is next to the Supreme Court. The Court of Appeal has jurisdiction to entertain appeals on all matters coming from courts of superior jurisdictions like the Federal High Court, State High Court, National Industrial Court. Even matters coming for the Sharia Court of Appeal can be, and the Customary Court of Appeal can be appealed to the Court of Appeal. Then we have the Federal High Court. The Federal High Court used to be a revenue court. However, subsequently, by virtue of Section 251, Sub 1, Paragraph F of the 1999 Constitution as amended, the jurisdiction of that particular court changed. And if you go to that particular section, you get to see that the jurisdiction of the court has to do with matters related, federal matters relating to federal government agencies, interpretation of federal laws, patent, trademark, copyright. These are matters that are entertained by the Federal High Court. It has exclusive jurisdiction. So when you go to Section 51 of the Constitution, you get to see those matters. The Federal High Court has exclusive jurisdiction to entertain. Then we also have the State High Court and the FCT High Court. They are courts of coordinate jurisdiction with the Federal High Court. The State High Court has unlimited jurisdiction to entertain civil and criminal matters, except for matters that are within the jurisdiction of Federal High Court and matters that are within the National Industrial Court and other tribunals that we have, like the Securities and Exchange Tribunals, like the Tax Appeal, like the Tax Tribunal. All those, some of these matters are exclusively the jurisdiction of these tribunals and are not meant for the State High Court. But generally, the State High Court has jurisdiction to entertain civil and criminal matters. Then we have the National Industrial Court. The National Industrial Court is there to entertain matters relating to labor, where there are labor issues, let's say between employee and employer, master-servant relationship, trade unions, trade organizations. The appropriate court to entertain such matters is the National Industrial Court. And we have the Sharia Court. The Sharia Court is there to entertain matters relating to Islamic law. If parties are subject to Islamic personal law, then they are submit themselves to the jurisdiction of the Sharia court for their matters to be decided. Then we have the customary courts, which is there to entertain matters relating to customs and traditions of the people, as I earlier said. And we have the magistrate court, is an inferior court too. The magistrate court entertains civil and criminal matters, even though the magistrate court in the north if it is entertaining civil matters, is regarded as district court. There is still the same judge that sits as a magistrate and sits as a district judge. It's just a change of nomenclature. However, the jurisdiction of the magistrate court is limited. It's not all matters that are entertained by the magistrate court, even though they have jurisdiction to entertain civil and criminal matters. Then we have the area courts. The area courts entertain matters similar to that of this customary court, only that is in change of nomenclature. In the notes, they are called area court, while customary courts are called uh, in the south. So let's look at civil law. When we're talking of civil law, we are just talking of private rights of citizens and obligations towards each other. As private citizens, we have obligations towards each other. Obligation not to disturb your peaceful possession of property, obligation not to lie against you, not to disturb your peaceful possession of property, that's trespass, not to lie against you, that's defamation, not to copy any of your product or anything like that. All these are obligations we have towards each other. So if in case somebody uh, violates such rights, such private rights, you can sue the person to court and obtain remedies and damages. Then we have the Nigerian criminal justice system, which we are talking about the Nigerian criminal law, which is there to ensure that uh, uh, relations is there to enforce rules of conduct, usually statutory. Criminal law are usually statutory, and criminal law is the body of law that relates to crime. uh, it prescribes conduct passive, threatening, harmful, or otherwise endangering the property, health, safety, and moral welfare of all citizens. So that is why there are some things that, even though we commit against individual, but because it's harmful to the general society, the state will take it up and prosecute it as criminal offense, especially when it is backed up statutorily, when there is a law on ground that says if you do such a thing, then there is a punishment. Because Section 35 of 1 of the Constitution says for anybody to be punished for an offense, that offense must be prescribed and the penalty, that offense must be defined and the penalty prescribed. So for anybody to be punished for such offense. So we've looked at the Nigerian legal system. This is just for you to have, as participants, to have an idea of what the Nigerian legal system is about. So let's quickly look at regulatory agencies regulating business in Nigeria. What are the relevant regulatory agencies? So we have the Corporate Affairs Commission, the CAC. When we talk of the Corporate Affairs Commission, it was established by the Companies and Allied Matters Act, 1990. It is the regulatory agency in charge of registration and regulation of business. It's responsible for the registration and regulation of business and non-business organizations, such as companies, business name, and incorporated trustees. So you are running a business, you want to register. You want to register that business. That business, you are running it to make profit. What agency are you supposed to approach? The appropriate agency for you to approach is the Corporate Affairs Commission. You are running a non-business organization like church, non-governmental organization. The appropriate agency you are to approach is the Corporate Affairs Commission. You can register it as an incorporated trustee, a business name, or companies. And by virtue of Section 7 of 1 of the CAMA 2020 as amended, it sets out the function of the CAC to include regulation. It regulates the formation of companies. It supervises, because at the initial stage, CAC plays a part. Pre-incorporation, CC plays a major part in it before you incorporate. It incorporates the company. After it incorporates the company, it also plays a part in the management. Because if there are any changes as to directors, shareholders, you will always need to notify CAC of such changes. If not, if CAC are not aware of any change and they want to conduct a search on your company and it's not there, it's going to affect your business. If you feel your business is no longer a going concern and you want to wind up, the appropriate agency to approach is CAC, and CAC maintains a company registry in all states of the federation. All states of the federation, it has a company register. That's why if you register your company with CAC, there's a file kept where you get to file your annual returns every day and the rest. So it also includes power to carry out investigation into the affairs of the company if the situation demands. CAC has, because once you are registering your company with CAC, you give them what the object of the company is. So they will, based on that, CAC expects you to run your company based on the object. And once they discover that you are no longer running your business based on that object that you supply to them, CAC has the power to investigate and take over the management of such company or such church or such organization by either appointing new directors or new trustees to such organization. Then we have the Federal Inland Revenue Service. We look at that subsequently in detail. We have the Central Bank of Nigeria. We all know that the Central Bank of Nigeria is the bank of bankers. It's the bank of last resort in Nigeria. It's the apex bank. It was established by the 1915 Act of the CBN, but the current legal framework for the CBN is the 2007 Act. And CBN plays an important role in ensuring that the Nigerian economy is buoyant. CBN rules out general policy on how the economy should be run. So they come up with a number of policies, like all these intervention programs we are seeing. That's the role CBN is playing, and they also regulate financial institutions, their relationship with customers, to ensure that customers are not being exploited, and financial institutions, because they roll out general guidelines for financial institution on how to carry out their banking and financial transaction. So CBN plays an important role. For, like, of recent, they reviewed the lending rate from a certain higher percentage to a lower percentage. All this is to encourage business within Nigeria. Now we have the Asset Management Corporation of Nigeria, AMCON. AMCON is just there to ensure liquidity flow in the Nigerian financial system. So AMCON is always there to buy off non-performing loans and debts within a bank. Once they will approach a bank, and they will get to see the balance sheet of that bank, and they will get to see what loans are not performing. Who are those people that collected loans from these banks and are not servicing such loans? As a result, they've become toxic. So what AMCOM does is to severe and manage such toxic loan. To break it down, let me give you an example. Let's say there is a company called Johnson and Johnson Nigeria Limited. Johnson and Johnson Nigeria Limited approached Guarantee Trust Bank. They borrowed money of about 100 million from Guarantee Trust Bank. But however, Johnson and Johnson Limited started servicing the debt as agreed with Guarantee Trust Bank. But subsequently, there was a problem. They weren't servicing the loan as they should, and as a result, it became toxic to the bank's financial, the balance sheet, and because it affects business. And as a result of not servicing that loan, there's no money to be paid to other customers who will approach the bank for similar loan. So what AMCOM will do in this case, AMCOM will approach GT and check, okay, Johnson and Johnson Limited have not been servicing their loan over a time. So what will we do? They will just buy off the loan from Guarantee Trust Bank. So they will pay Guarantee Trust Bank the loan and everything borrowed by the interest borrowed by Johnson and Johnson Nigeria Limited. Then AMCON will go after Johnson and Johnson Nigeria Limited for the money they owned Guarantee Trust Bank. So that's the responsibility of AMCON, to ensure that there's liquidity flow in the Nigerian financial system. So severance and management of toxic assets and non-performing loan. Then we have the Standard Organization of Nigeria. We'll also look at that subsequently in detail. Then we have the Federal Capital Development Authority, or the State Commissioner for Lands and Local Government Council. So when you are into a business that has to do with land, definitely you need to approach the appropriate authority, the designated authority, for the purpose of obtaining or getting your certificate of occupancy to occupy a land to carry out your business. So if you are in Abuja, you know you need to approach the Federal Capital Development Authority and the rest. If you're in other states, you know the right agencies you need to approach. So the Federal Inland Revenue Service plays an important role here. The Federal Inland Revenue Service used to be an arm of the Federal Board of Inland Revenue. The Federal Board of Inland Revenue, it is by virtue of the 2007 Act that established the Federal Inland Revenue Service as an autonomous organ from the Federal Inland Board Revenue. So it's charged with the responsibility of collection and administration of federal and corporate taxes. So for federal and corporate taxes is the responsibility of the Federal Inland Revenue. It does not just stop at collection and administration of federal and corporate taxes. By virtue of Section 2 of the Act establishing FIRS, it empowers FIRS to administer and to administer and by virtue of Section 2 of the Act, to control and administer the different taxes and laws specified in the first schedule of the Act. And it also empowers them to administer by virtue of Section 25 to administer and enforce the various tax enactments that are obtainable in Nigeria. And what are those tax enactments obtainable in Nigeria? We have the Stamp Duty Act, we have the Added Tax Act, we have the Personal Income Tax Act, we have the Company Income Tax Act, and various other acts, financially related acts. So these are within the purview of the FIRS to administer to ensure enforcement. And for the purpose of this module, we'll quickly just streamline and look at the value added tax. And the value added tax is a very important tax because the value added tax is just a tax, a consumption tax that is levied repeatedly on a product or services that is being offered to people. That is why every time, if you are using the MTN line, every time you make a call, MTN will charge you for VAT because it's a consumption tax that is that is levied repeatedly on a product or services being offered to you. If you go to a supermarket and buy a particular product, you will see VAT included for that service. So that VAT that is being collected is not for the shop owners, neither is it for the any network provider. It is for the federal government. So what they will do is they will remit that money depending on the agreement they entered with the local VAT office, which is the FIRS office they registered with. It could be monthly, it could be weekly. They choose to remit the 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 VAT. So if you own a business whereby you are selling a product or providing a particular service, you will need to go and register with FIRS for collection and remitting of value added tax. So once you are offering or selling a product, you are supposed to charge for that VAT, and you have to remit it to your local VAT office. Even though it's not all products that are vatable, by virtue of the Finance Act of 2019, you get to see some of the products that are not vatable. And for example, cultivation on unprocessed agricultural produce are exempted from VAT and enjoy pioneer status, thus are largely exempted from federal taxes. So VAT is very important if you are doing any other business. If you are offering a business that has to do with or you are offering products for sale or services to people, you need to register with the FIRS. You obtain your VAT registration number is given to you for the purpose of remitting each time to the local VAT office. Then we have the Standard Organization of Nigeria. The Standard Organization of Nigeria is the sole statutory that is vested with the responsibility of standardizing and regulating the quality of products as contained in their inventory. It's not all products. Pardon the mistake on the slide. It's not all products that are within their inventory, because they normally list out products that you need to certify with them. So once you don't do that, it becomes a problem. And the statutory functions of standard organization of Nigeria includes to investigate the quality of facilities, materials and products in Nigeria, establish a quality assurance system including certification of factories, products and laboratories, to ensure reference standards for calibration and verification of measures and measuring instruments, to compile an inventory of products requiring standardization, to foster interest as contained, and they advise the state and the federal government on specific problems relating to standard. And also, one thing is that the standard organization has the powers of seizure and classification and destruction of substandard products, including powers to seal up premises where defective products are manufactured. So these are some of the functions of the standard organization of Nigeria. So let's look at how do you register with the standard organization of Nigeria. The Standard Organization of Nigeria is a body responsible for standardizing products within their inventory as contained on their site or anything they release, uh, any circular released by them. Because when you go to their site and other site I will subsequently refer you to, you get to see inventory of products that can be certified by Standard Organization of Nigeria. So we cannot pick each product and discuss how you are going to register it, because it's going to take us the whole of this week to be picking one product and detail how. So what I just did is just to give a general uh, explanation on how to register uh, products on with standard organization, those products that are within their inventory. And they have two methods of registration, mainly two, and there is another one that we'll also look at. But the main one are the e-product registration for imported and locally manufactured products. So if you want to register your product, you could just visit the website son.gov.ng. On the homepage, you click on e-product registration for a new company, click on new account, you enter the RC and business number, a valid email address, you click sign a password. So you go to the sign in page and enter the RC number, email address, and password. You know, you have to create an account with them before you can do that. So it's just step by step. The next page, you fill in the company details, continue, you make payments to them. You after you make payments, then you click on the e-product payment. Then you scan and upload documents in JPEG or PDF formats, like your CAC certificate, picture of the program, power of attorney, trademark certificate. So these are some of the documents you upload to them. So for this e-product registration procedure with standard organization can be for imported and locally manufactured products. You can see on the slides, I just listed 1 to 8 for just the procedure for the registration. You can go to any standard organization office closest to you to make inquiries. And where you can't do it yourself, there are always agents available to help you do it, to help you make the inquiries. I think lawyers can do that for you as well. Then we have the mandatory conformity assessment program. Mandatory conformity assessment program, which is called the MANCAP. This one is mandatory. This one is also part of the procedure when you want to certify your product uh, with Standard Organization of Nigeria. So the scheme is put in place by Standard Organization to ensure that all locally manufactured products in the country conform to the relevant Nigerian industry standards before such products are presented for sale in the market or exported. So they must meet the Nigerian industrial standards before they are they are being distributed in the market for sale. So, what are the procedures for the mandatory conformity assessment program certification involved? It involves inspection of the production process. You go and inspect your factory, the sampling and testing of product against the relevant Nigerian industrial standards to confirm compliance through conformity assessment. Report of inspection and test results are complied by state and forwarded to the product registration directorate for evaluation and recommendation for SONS management approval. If the product meets the requirement of the relevant Nigerian industry, MANCAP logo, it will bear the MANCAP certificate and MANCAP logo, which bears a unique number for that product, is issued for the product upon payment of applicable testing. So for details on this, you could go to www.618biz.com, or you could just Google registration with Standard Organization of Nigeria. So you get to have details or step-by-step details, because it's not something I can give you here of how to go about registering with Standard Organization of Nigeria. Then the Standard Organization of Nigeria also has a conformity assessment program called the Standard Organization of Nigeria Conformity Assessment Program for goods shipped to Nigeria. So for goods that are being shipped to Nigeria too, they will need to certify, especially when they are within their inventory. The Standard Organization of Nigeria will need to certify that. So for detail on that, you could go to www.cortina.com, cortina.com, or you could just Google export guide to Nigeria, export guide to Nigeria. It will bring out the inventory of products that if you are shipping to Nigeria, that you need to certify with the Standard Organization of Nigeria. So these things are necessary, especially when you want to go into the distribution and sale of such products. So you definitely have to ship them to Nigeria, and the Standard Organization of Nigeria will have to certify same. So let's look at registration with NAFDAC. As I said, it's not all products that are registered by, certified by the Standard Organization. NAFDAC too has a mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and the registration of the categories of products such as drugs, medical devices, and cosmetics, etc. That is controlling, maintaining the distribution, advertising, exportation, importation, and manufacture, and the registration of the categories of products such as food, drug, medical devices. So these are things that the Act creating NAFDAC empowers them to do. So anything you want to do that relates to food, drugs, medical devices, and cosmetics, you want to go into distribution, you want to advertise, export, import, manufacture of such things, then you need NAFDAC. So all businesses dealing with food and related products subject to regulation by NAFDAC, as it's must be registered with NAFDAC, because it's unlawful for you to market any drug or consumable goods in Nigeria to public without registration with NAFDAC. So let's look at the categories of products that are administered by NAFDAC. That if you are into production of such, or distribution or manufacture of such products, you need to register with NAFDAC. One is food and water. If you are into the production of food and water, you need to go and register with NAFDAC. If you are into the production of drugs, of all kinds of drugs, that is, when I say drugs here, I'm talking of medications, not drugs as in illegal drugs like cocaine and the rest. I'm talking of medications, drugs, and medical devices. So you need to register with NAFDAC. If you are into the distribution, manufacture, importation, exportation of herbal and cosmetics, you need to register with NAFDAC. Vaccines and biologics, you need to register with NAFDAC. Chemicals, you need to register with NAFDAC. Veterinary products and narcotics, you need to register with NAFDAC. So what we will do now, we'll look at the procedure for registration with NAFDAC. The truth is that we cannot pick each category and discuss, because under food we have different foods. Under water we have yes, water is general. The foods, we could have beverages, we could have these kits, we could have other things. So we cannot pick each one and say we are going to discuss the method of registration with NAFDAC. So what I did was just to pick the key requirement, and I just specifically use drugs. So even though the category of products are different, the specific documentation doesn't vary a lot. The procedure is almost similar. So those specific documentations vary for different drugs and food categories. The general registration procedure is similar. Broadly, is a two-stage process. First is application for approval to bring in samples when you are importing, then application for full registration for all kind of products, because they will need to examine the product. Even if you are manufacturing locally, they need to visit the factory to see how you do it. Even if you are importing too, they will need to visit. So though its registration may vary, the variation is not that much, as there is a similar uh, procedure all through. So let's look at uh, and for any further inquiry, you could just, if you're within Abuja here, the head office of is at Abuja. It's Zone 7, sorry, Abuja. That's where the head office for further inquiries. Then let's look at those key requirements. Key requirements are as follows, especially when you want to register drugs. We have different drugs for headache, for painkillers, for stomach ache. So what I did here is just generally I just give the key requirements generally for all. So if it's drugs, application is on a single product basis. For all products, it's on a single product. When I say application is on a single product basis, I meant that if you are applying, each application should be for a particular drug or a particular food product. Let's say for a particular drug. Let's say you have two drugs, one for headache, one for stomach ache. You cannot combine the application and tell NAFDAC to issue one NAFDAC registration number for the two. It has to be on a single product basis. For the headache, drug separate, drug for stomach ache separate. So each will have its own registration number. It will be registered differently by NAFDAC. You have to have a written application stating the name of the manufacturer. If you are the manufacturer, you state any of the name of the manufacturer, the brand applicable. You complete your NAFDAC application form, then certificate of incorporation with the Corporate Affairs Commission if it is the company that is you're importing or something. Then you have 5 copies of the product dossier. When we say 5 product dossier, what I meant here is collection of various documents and data. Let's, for example, this vaccine for corona, it had to undergo several trials, analysis, scientific experiments. So if you want to apply for NAFDAC approval and to obtain registration number from NAFDAC, you need to supply such product dossier to them to see how effective your research is and how you've conducted trials and it has proven effective and the drug is the efficacy is quite good. Then you have 3 packs of the product samples. Then notarized original copy of the duly executed power of attorney from the product manufacturer. Let's say you want to import the product from India. Let's say this vaccine, you want to import it from India, Pfizer, India. So there's this document they need to give you, like power of attorney or manufacturer's agreement to the fact that yes, they've authorized you to come and distribute this product in Nigeria or to manufacture, or they franchise a right to you to carry out the manufacture of this product in Nigeria or to import it. So that document, this power of attorney is just simply saying that they've given you that power for you to do on their behalf some of these acts which they would have done it themselves. So it's that particular document. It's just a document that's saying, okay, you empower somebody to do the following acts on your behalf. So you need to notarize. Notarize is just a signature of somebody. In Nigeria, we have what we call notary publics. So the notary public will just notarize with his signature to show that that particular document is authentic. Then we have the certificate of manufacture issued by a competent health or regulatory authority in country of origin. In Pfizer, that vaccine you went to import from India, let's say is Pfizer or something. So that certificate of manufacture must be authenticated too by the Nigerian nation in that country. India being a Commonwealth country, Nigeria being a Commonwealth country, we have the High Commission there, the Nigerian High Commission there, which you could just approach for your product to be authorized. Then, in the absence of any Nigerian High Commission, you could approach a British High Commission and the ECOWAS country mission to authenticate same. Then we have contract manufacturer agreement. In the absence of a power of attorney, you can also sign a contract manufacturing agreement, which will be executed to and authorized by a notary public in the country of manufacture. Remember, we said NAFDAC are not just only in charge with the importation, but also the distribution of such drugs. And pharmacy, what pharmacy do normally is distribution and sales. So if you want to go into distribution of such drugs, you need certificate of pharmaceutical products duly issued and authenticated, current pretender pharmacist license to practice issued by Pharmaceutical Council of Nigeria, premises registration, certificate of registration of brand name with a trademark registry, especially this particular provision that has to do with registration of brand name with trademark registry in the Ministry of Commerce here in Nigeria. Whether you are importing or you are exporting, if you have a trademark or a trade name, now that will expect that you've registered such trade name or trademark with the Ministry of Commerce, with the trademark and patent registry of the Ministry of Commerce. So if you don't know how to go about doing that, there are lawyers and agents that do the registration. And once you go to that particular registry at the registry of the trademark and patent and industrial design of the Federal Ministry of Commerce, there are lawyers there who are employed to carry out such registration. And there are lawyers who are registered as agents that can help you process your application. Then if you are importing, you need to bring letter of invitation from manufacturer to inspect the factory, stating full name and location of the plant. Then you pay applicable fee only if documents are confirmed to be satisfactory. uh, NAFDAC recently introduced an online method of registry, and they call it the NAFDAC Automated Product Administration and Monitoring System, NAPANS. So once you go to www.napans.org, you get to see the procedure. You first of all sign up and register an account as a client with NAFDAC. After signing in, after you've created an account, you get to select product you want to register. That means obviously you must have met all preconditions necessary for registering that particular product, because you cannot just begin to register a product without meeting those preconditions that NAFDAC expects you to fulfill before registering a product. If they will have to go and inspect, they will go and inspect. If there are samples you need to bring, you need to bring. Then complete the application forms, you make payments, you process your application. Though it's something I guess they started in April or June of this year. So I don't know how effective this procedure, e-registration procedure is. But for any inquiry on it, if you're in Abuja here, you can go to Zone 7. Even though on the website they'll give you for inquiries and something, but sometimes if you call the numbers and the rest, nobody will even pick your call or even attend to you. So sometimes it's better you visit the office physically where they will attend to you. Then the next topic we are going to look at is types of business organization and the legal implication of various types of this business organization. You are running a business. Is as a sole proprietor or as a partner, as partnership or a company? What are the legal implications of deciding to run that business as a sole proprietor? What are the legal implications of deciding to run that business as partnership? So this is what we'll look at. So when we talk of business organization, we are talking of legitimate ventures to make profit. You are into, you are into that venture to make profit, and it must be legitimate, not illegitimate. So what are the types of business organization? We have the sole proprietorship, we have the partnership, and we have company. So let's quickly look at sole proprietorship and its legal implication. As the name implies, sole proprietorship, you are the sole owner of the business. You own the business alone. You take decisions alone. You spend the profit alone. If you like, you can even spend the capital. You take decision. If you die, the business dies with you. So that's one of the implications of running a sole proprietorship. And when you borrow money from any financial institution, your liabilities are unlimited, in the sense that if you borrow money, the financial institution can come after you personally liable for the debt and liabilities of the business. Let me use this example for you. Mr. Johnson runs Johnson Business Ventures, and he went ahead to borrow money from Guarantee Trust Bank, and he was unable to pay that money because he's running a sole proprietorship. And even if the company is registered with CAC as a business name, and he was unable to pay that money he borrowed from GT Bank, GT Bank can come for his personal belonging, his car, his mattresses, the pots in his house, his gas cooker, all his personal belonging, for them to offset that particular loan he borrowed from there. So that's one of the legal implications of running a sole proprietorship. Your personal asset and properties of the owner may be seized to offset the debt of the business. The business, even registered with CAC, is not a separate legal personality from the sole owner. The owner's personal asset and business are inseparable because he's running a sole proprietorship. And sole proprietorship are registered with the CAC as business name. When you want to register, you don't want to run a company, you just want to run a simple business, you're registered with the CAC as business name. So what this uh, paragraph is saying is that even when you register your sole proprietorship as business, does not confer legal personality on you. So let's look at partnership. As we know, partnership is when two or more people come together to run a business for the purpose of making profit. So you decide to enter into partnership with your friends. For instance, Mr. John and Mr. Johnson decide to come together. They decided to come together to form a business for the purpose of running that business to make profit. And there's one thing you need to know about partnership. Partnership can be limited partnership, it can be general partnership. When we say general partnership, we're saying Mr. John and Mr. Johnson decided that they will be partners and they want to be involved in the day-to-day running of the business. They want to be involved in the day-to-day running of the business. So Mr. Johnson wants to play a part on how the business is being run. Mr. John too wants to play a part in how the business is being run. He wants to be part of the administrative duties. He wants to play a part in running the administrative duties of that business. So in that regards, Mr. John and Mr. Johnson are general partners because they are involved in the day-to-day running of that business. But in the case where Mr. Johnson and Mr. John decided that yes, they want to run a partnership for the purpose of making profit, but Mr. John will says to Mr. Johnson that okay, I don't want to be involved in the day-to-day running of the business. I just want to invest. I just want you to run the business. Me, I'll just sit and relax. I'll just invest. There are implications. As general partners, you have unlimited liabilities similar to that of a sole proprietorship. General partners are at risk of having their personal belongings seized to offset the debt. That is when they eventually borrow money from a financial institution as general partners and they are unable to pay because they are involved in the day-to-day running of the business. They can come after their personal belongings for the debts to be offset, to be for the debts to be offset. So the liabilities of the partnership business, because a business is made up of two or more partners, each sharing the business's debts, liabilities, and assets. So once you decide to run a general partnership where you and your partner are general partners and you decide to borrow money from any financial institution, if you're unable to pay that money and they want to offset the debt, you'll come after you personally, your personal belongings for them to offset that debt. But in the case of limited partnership, when two or more partners go into business together, but one or more partners are only liable up to the amount of the investment because one of the partners is not involved in the day-to-day running. So once you are involved in the day-to-day running of the business, you become personally liable. But if you are just a limited partner, your liability is limited to your investment in that particular partnership. And there is something you need to note about partnership. For you to be regarded as a partner in any partnership, you must partake in the profit sharing. And except agreed otherwise, parties are to share profit equally, except you decide that you don't want to share profit. Mr. John, Mr. Johnson are partners. Mr. John is a limited partner. Mr. Johnson went to GT Bank, borrowed money for the purpose of running the business. They were unable to pay the money. So if GT is coming for the loan, as for Mr. John being involved in the day-to-day running, GT will come after his personal belonging. As for Mr. Johnson, who is a limited partner in the business, GT can only come for them to offset the debt. They cannot go after his personal belonging. Rather, it's only limited to his investment in the company. Then we have uh, companies. Its legal implication. What is the legal implication when you decide that today you want to register a company? What are the legal implications? There's something unique about companies. Companies are in law regarded as artificial persons. So in law, we have what we call juristic person. When we say juristic person, that means such persons can be sued and they can also sue. So juristic person can be an artificial person in the case of companies, and it can be natural persons in the case of human beings. So once, let's say, Mr. Johnson, who is running Johnson Business Venture, decides that he wants to upgrade his business name to a company, he wants to change it to Johnson and Johnson Nigeria Limited. He is the promoter of the company. He's the one that paid for the registration. He's the one that did everything. So from the date certificate of incorporation is issued to Mr. Johnson for Johnson and Johnson Nigeria Limited. Mr. Johnson becomes a separate legal personality from the company. Him and the company are not the same. The company is now an artificial person. So the company can do some things that human beings can as a company. So what Mr. Johnson can only be in that company is either he's a shareholder or he can be a director. He and the company, unlike sole proprietorship, are not one and the same. So if they cannot, in case they borrowed money in the name of the company, Johnson Nigeria Limited, GT cannot come after Mr. Johnson's personal belonging because Mr. Johnson is only a shareholder in that company. So they can only come after his investment in the company, which is limited to his shares in the company. So, because as you register a company is an artificial person, the company can do a number of things that a human being can do. That is why here we have the company being a human being of its own can do the following in its registered name. So registering a company has a lot of advantage. It offers a lot of advantage to you. because you can buy and own properties in the name of the company. Mr. Johnson can own and buy properties in the name of Johnson and Johnson Nigerian Limited. That is why sometimes you will see some certificate of occupancy rather than carrying individual name, it's carrying names of companies. Then you can enter into contract. You can enter into contract in the name of the company. The company can sue and be sued, and it enjoys perpetual succession. When I say it enjoys perpetual succession, it means that the company can live forever. For example, First Bank. If you check the logo of First Bank, you will see it's created since 1894. Are you telling me that the initial shareholders, the the first subscribers, the directors that began First Bank are still alive? No, because First Bank is an artificial person of its own. Different shareholders will come and go, directors will come and go. So that's one of the advantages of the legal implication of running a company. Then you can also apply for loan in the company's registered name. So that's something about unique about companies. It tends to separate the person who runs the business from the company. The company too is regarded, even though human beings are responsible for running the company, but in the eyes of the law, it is an artificial person, and there are certain things that that company can do. So these are the legal implications. So let's look at registration of business and non-business organizations. Why do you have to register your business? Because registration of business organization is done at the Corporate Affairs Commission, whether be it a business name or a company corporation. We've talked, as I said at the beginning of that class, at the beginning of the class while we were talking about Corporate Affairs Commission, I said the Corporate Affairs Commission is responsible for registration of both business and non-business organization. For business organizations, mainly they are registered with the CAC as business name or companies. Then any business, whether small or large, in the long run benefit from corporate and physical product registration. There are benefits that will accrue to you when you register your company. For instance, if you want to borrow money from bank and your business is not registered, the bank will find it very hard. And you want to borrow money in the name of that business to from bank, the bank will find it very hard to lend you that money because that business is not registered. And normally you see banks conducting search before they grant you any money that you are looking for. Then for instance, there are some financial incentives that the federal government will want to grant. And if your companies are not registered, if your company is not registered, you are not expected to benefit from such financial incentives. For instance, this loan that you hope to apply for, it's one of the things that the federal government expects you to apply with your company or something that is registered with the Corporate Affairs Commission, like the survival fund that was distributed by the federal or is being distributed by the federal government. You also need a company and it must be registered and you must have evidence of your tax payment for you to be able. So in the long run, even payment of tax is a moral obligation and social responsibility for individuals. So you need to register your business. So let's look at start small business startup procedure. You don't have a business, you intend to start a business. Definitely you carry out sort of a survey to see what business is suitable to support that your idea is suitable, what environment is suitable for that your business. Then you look at a suitable business name to support that your business idea. Suitable location, you have to get a very suitable location for where your business will profit. Register the business name with the Corporate Affairs Commission. Make sure you choose a name that is easy to pronounce and remember and has a relationship with the type of business. You registered with the FIRS, register with NAFDAC where necessary, register with Standard Organization of Nigeria where necessary. This will enhance the value of your products or services you offer in the market where people see a mark of NAFDAC, Standard Organization of Nigeria. So this will enhance, because over time it has been built in us subconsciously. Like if we are buying some food, drugs, we check for the NAFDAC registration number. So if you are into food, drugs, and other related items that are within the categories of items for NAFDAC to administer, and it's not registered, most people, even though yes, the product is of good quality, is good, but once people don't see that NAFDAC registration number, they will be reluctant to want to patronize your product. So you need to do the needful. So let's look at the procedure and documents to be submitted to CAC for registration of business name. As we said, the CAC is responsible for registration of business and non-business organizations. And business organization with the CAC are registered as business name or incorporated, as business name or companies. Business name, especially when you are running sole proprietorship or partnership and you don't intend to make it a company, then you need to register it with the CAC as a business name. So what we are going to look at now is the procedure and documents to be submitted to CAC for registration of a business name. So before you commence your registration, there are things you need to know if you want to register with the Corporate Affairs Commission. The first is you need to do reservation of name on your CAC portal. How do I obtain my CAC portal? CAC has agents responsible for accredited agents responsible for registering of companies and business name, uh, incorporated trustees, TC. So these agents are chartered accountants, chartered secretaries, or lawyers. They are given, uh, once they've applied for accreditation, they will be accredited by CAC. CAC will give them accreditation a number. They will go and open their portal. That portal is created for the purpose of registering companies and business name. But you as an individual, let's say you want to register your own business name, you can also create your portal on the CAC website for the purpose of registering only your own business name. You cannot register for others because you are not an accredited agent, but you can register for your own self. So you go to the CAC portal, you create, you register with them, you create a portal. So it's now this portal now that you are talking of reserving a name on the CAC portal. So you come to the CAC portal to insert that name you want to reserve. And reservation of name is done by putting the name of the business you want. You'll be given two slots to put two different names. So it's up to the commission to look at the name that is not in use, name that is not similar to another name that does not contain Abuja or International Chamber of Commerce. Because at the point of inserting those names you want to register, CAC will bring out a warning, like something warning you, like, okay, you cannot use this name and this names, because there are certain names that are restricted. If so, such names you cannot use them except, and so there are conditions for using. There are some names that you cannot even use them at all, especially those names that are already in use, because those names that could easily be passing off and the rest, because two people cannot be using similar names to run a business, so it will affect competition and the rest. So duly, after you've submitted the name and CC looks at the name submitted to them, they will approve a particular name to you, which will be reserved for 60 days. They reserve that name for 60 days, and that 60 days you are expected to make payment, fill the form and make payment. Once you make payment, then at the expiration of that 60 days, it does not matter because you've already made payment. Because after that 60 days and you've not made payment, you are going to lose the name, and the name will be up for grabs. Anybody can use that name and it's no longer exclusively reserved for you. So if the name you submit the name and the name is approved, CAC will send notification to you informing you that the name you submitted has been approved. They will tell you which of the names is approved. If it is rejected, they will tell you it's rejected and they will give you reason for rejecting that particular name. Then if it is rejected, you still enter another name and it's not free. You pay money for that. And there's also remitter charges for every application you submit. So if the name is approved, they will send a mail to you telling you that the name has been approved. You will enter a code. There's an availability code that will be given to you, which you enter. Once you enter, it will direct you to the page where you start filling forms regarding your business. You will fill information regarding the nature of the business, information page on the national identity card, because there are certain information they will ask for, which are on the national identity card and the driver's license and proprietors who are the proprietors of the company. So once you fill in those information, you will make payment. After you've made payment, you will download the form. You download the form, then you will sign and you will attach passports of the proprietors of the company. So after you've made payment, there is need for you to once again upload these documents to CSC. You scan and upload the document. So in scanning and uploading the document, you scan your availability, your notice of approval, you scan your payment, the payment receipt, then you scan your registration document. So it's left for CAC to look at these documents. If there is no mistake, anything, they will not query it, they will just approve it. Then you are good to go. So they will issue a certificate that your business has been registered as a business name with the Corporate Affairs Commission. They issue a registration number and everything. Then you are good to go. So now you have a registry with uh, with the Corporate Affairs Commission. So example of business name at Tayo and Tayo and Co. Global Ventures Farm, etc. That's business name for you. So let's look at procedures and documents to be submitted to CAC for registration of company. You want to register a company, just like business name. What are those documents to be submitted to CAC for registration of a company? What are those documents you need to submit to CAC? So, just like unlike a business name, we have different types of companies. So we have the private limited company, we have the uh, uh, public limited company, we have the unlimited company, we have a company limited by guarantee. So you will look at the kind of business you want to run, then you will decide which of the company you want to register. But considering that the kind of nature of loan you want to collect and the number of people involved in the business, I guess it's more advisable for participants to register the private limited company. The private limited company by Karma of not the recently amended Karma of 2020, the former Karma. I'm still using the old Karma is that CAC are yet to begin implementation of the new Karma. So once they begin implementation, I will have to change this provision I have in the first paragraph here. This is based on the old Karma. Because by the old Karma, private limited company, you need at least two shareholders, at least two directors for you to begin registration. So company register as a public limited, you need at least two shareholders. Then there is no cap as to the number. Then the share capital for private limited company by the old Karma is I guess 10,000 naira. Then for public limited company is 50,000 naira. But all these are not even adhered to by the CAC, because CAC have rolled out a general policy for the minimum share capital for each of these. And for minimum share capital for private limited companies, 1 million uh, share capital. And when we are talking of 1 million share capital, 1 million naira divided into 1 million ordinary shares of 1 naira each, for depending on how you choose to share the shares among the shareholders of the company. You are not saying you are going to pay 1 million to CAC, or that's an artificial valuation of the company. You are saying this my company is worth 1 million naira. So anybody that wants to buy it you the share capital is what is 1 million. So this is how you go about it. So you are just giving people like okay an idea of the artificial valuation of the company. And normally, public limited companies are usually quoted at the stock exchange market and are highly regulated by the Securities and Exchange Commission. A private limited company is more suited for small, medium businesses. So, as I said earlier, a private limited is more suited for small and medium businesses. So the first step to registration is reservation of the proposed name, just like what I said when I was talking about registration of business name. You look at the name of the company, but in this case, any company you want to enter, you must carry the name limited. Just like the business name, you can, if you are a director or shareholder of that particular company, you can create a portal and do register yourself. But if you feel it's going to stress you a lot, you can't do it yourself, you can employ or you can get an agent. You pay him his professional fees and he will register the company for you. The first step is reservation of name, proposed name, using your portal. If you're registering yourself, if you're a shareholder or director, you can create a portal for the purpose of registering that your particular company. And this is only applicable to pre-incorporation because there is what we call post-incorporation. Post-incorporation is when you want to make changes as to your share capital, directors, secretaries, and the rest. So you must use an agent to do that. You can't do it yourself. You must use an agent. It's pre-incorporation that you can do yourself. Then a private limited company, after reservation of a proposed name, if the name is approved, the name must not be similar to any other name, and it must not be a name that is in use. It must not be a restricted name, or it must not carry things like Abuja. If you Abuja, you must obtain consent from the honorable minister. You don't carry International Chamber of Commerce and the rest because it tends to paint a position to the populace that is associated with that particular stuff, except you have permit or something to go about doing from that particular organization that you want to associate the name with. Then you can go ahead with show them you once registering or uh, once you're entering the name, you attach that particular approval to them to show them that yes, you obtain approval that you can use that name. So once the name is approved, a notice will be sent to you that the name has been approved. That is notice of approval carrying a code, which you enter the code. The code will direct you to a particular page where you will enter details of the name of the company, the address of the company, the share capital of the company, uh, how are you going to divide the share capital of the company? Is it 1 million naira divided into 1 million ordinary shares of 1 naira each? Is it 1 million of 1 million ordinary shares divided into 200,000 shares each? Depending of 1 naira each, depending how you decide to share the shares. For instance, you have four shareholders, it could be, and the company is 1 million share capital. You could decide to say, okay, four shareholders, you are dividing the shares for 250,000 ordinary shares to each shareholder. So by the time you do the calculation, it will make up for the 1 million naira. You must not allot all the shares at once. You can reserve some. All shares too can be transferred. So eventually, if you have another shareholder, you can allocate that shares to him. So you fill in those information of directors and shareholders of the company, your means of identification, either passport, international passport, national driver's license are very vital when it comes to registering with CAC because you will need to enter certain details you obtain from that information. So you need it from each of your shareholder, yeah, and directors and even the secretary of the company. Then after you've done that, you filled all the necessary information. There's what we call memorandum and articles of association. Memorandum will contain the objects of the company. What are the objects of the company? What does the company intends to do in terms of business? So these are what we call objects, and it regulates relationship with the company and outsiders. While we have articles of association, all these ones are there as you are, because the registration is step by step. You move from this step to another step, you move from this step to another step. So you get to encounter all this. So you have articles of association which you could just adopt or you could formulate yours. And these things, if you cannot do yourself, as I said, there are always agents, accredited agents that can do it for you. You make payment, you download the form, you sign where necessary. After signing, you upload the forms with the means of identification, with the notice of approval, with evidence of payment and the rest. Note that for a reservation of name, there is payment, registration fee, there is payment, and stamp duty. You also pay for stamp duty once you are registering. So all these are what you need to submit to CACs. If you upload, they will look at your application. If there is nothing, they will query. They will issue a registry, a company registration number, an RC number, a registration RC number for your company to operate. Then subsequently, a certificate will be issued. So basically, these are the procedures and documents to be submitted to CAC for registration of company and business name. What I have here is just a guideline of to give you an idea of how much it costs to register. It's not what is obtainable presently when you want to register companies. It's just for you to have an idea of, for participants to have an idea of how much it costs. So if you want to register a company or a business name, if you can't do it yourself, you can just get a professional to do it for you, and he'll tell you how much what the obtainable fees are for reservation of name and registration, and he will also inform you of his fees, how much you have to pay him for the services he will be offering or he has offered, or he will be offering to you. So let's look at our last topic of the day, which is the law of contract. Why are we discussing law of contract? Once you register this company and you are into uh, selling and buying, or you are into providing a specific service, all these are contracts you are entering into every day. Contract is not like you must sit down and draft one special document. No, contracts can be by conduct, can be oral, can be written. So we look at all this. So basically, contract is an enforceable legal obligations agreed upon by parties. That means there must be consensus between parties. And what are the basic elements or feature of a valid contract? Basic elements of there must be offer. When I say offer, is there must be a party making offer. Mr. Johnson and Mr. John want to go into a transaction. Mr. Johnson has a Mercedes he wants to sell to Mr. John. And there must be Mr. Johnson must offer to sell that car. Or sometimes it's the other way around. The person who intends to buy will ask, how much do you want to sell your car? So it's an offer. So it can be either way. An offer can also be this way, where you go to supermarkets, you see them displaying products on the shelf. That displaying of products is not an offer. They are just is an invitation to treat. When you pick that product and you approach the cashier, then that is you making an offer to the cashier. Then we have in the terms of contract where you see invitation to tender. They are calling for invitation to tender. So this call for invitation to tender, huh? This call for invitation to tender is also an offer. They are calling for contractors to come and make offer. So these are different forms of offer we've just looked at. And for there to be a contract, there must be an offer. Then we have what we call acceptance. If you make an offer to a party, for there to be a contract, the party must have accepted that offer. If not, the contract will not be valid. You cannot impose something on somebody without him willingly accepting that offer. So, and once there's offer, there must be consideration. Something of value must exchange hand. That is why you have to offer money or something of value in return for that thing that person is offering. But mostly is money that exchange hands. So when we talk of, these are the three basic elements of contract: offer, acceptance, and consideration. Then we talk of forms of contract. When we are talking of forms of contract, is either a contract is oral, written, or by conduct. So written is, parties will sit down and draft the terms of the contract, the express and implied terms of the contract. Well, by conduct, parties can just, by their conduct, enter into contract. For instance, a typical example I can give you is when you enter a taxi without even saying a word, then you know where the last bus stop of that particular taxi is, and you know the amount. So you just enter without saying a word. The driver will not say a word to you because he expects that this is the money you are going to pay when you reach, when you are being picked from a certain spot to another spot. So he's going to pay you that money. So you just pay him that money, and that's contract by conduct. Then contracts too could be orally. Parties could agree orally. Once they agree orally and they begin execution of such contract, then there's contract. Then capacity is not with everybody you can enter into contract. If you want to enter into contract, you must enter into contract with some persons of sound mind, not mentally challenged people, except at their lucid period. When they are lucid, that means that period that they are mentally stable. Then minors, you cannot enter into contract with minors, even though there's a case that says if a minor, if the contract you entered with a minor is for his necessity, so in such a case that contract is uh, valid, because that thing you entered into contract with him is of necessity to him, so such contract is valid. You can't enter into contract with drunk person, somebody that is drunk, except when he is sober. So legality too plays a part. If the contract is not legal, as we define the contract to be an enforceable legal obligation, every contract must be illegal for you to obtain. Where a contract is illegal, you cannot enforce such contract. I love to use this example of a prostitute. A prostitute cannot approach the court and say she wants to enforce payment. If somebody refuses to pay her, because up initial the contract is illegal, so it cannot be enforced. And parties must have shown willingness to contract. That is intention to create legal obligation between them and other parties. So let's look at privity of contract. Privity of contract simply means only parties to a contract can sue and be sued If you are not a party to a contract, you cannot sue and you cannot be sued. For instance, Mr. Johnson sold a car to Mr. John and the car has problem. So Mr. John's wife cannot sue Mr. Johnson for selling to her husband a car that is malfunctioning because she wasn't a party to the contract. But Mr. Johnson can sue Mr. John because these are parties, they are parties. So privity of contract is just saying only parties to a contract can sue. If you are never party to that contract, you cannot sue. However, there are exceptions to this general rule. There is for covenants running with land, where, for instance, the best example is, for instance, you buy a property from an estate, then you sold it. Mr. A bought the property from an estate B. Mr. B, when once you buy a property within an estate, there are these covenants that you enter into the estate. So if Mr. B buying property from Mr. A violates some of these covenants that are in place in the estate, even though the contract he entered is between him and Mr. A, the estate management can sue Mr. B for violating the covenants of that contract. So it's an exception to privity of contract. It's just one of the exceptions. I just want you to have in mind it's not like a general rule that if you are not a party to a contract, you cannot sue. The law has made provision for an exceptions. So another exception is contractual uh, contracts for chattel interference with contractual rights. Interference with contractual rights is when you enter into contract with another person and another person is trying to dissuade that person from carrying out that contract you enter with that other person. So you can sue that person who is trying to dissuade that. So these are exceptions to privity of contract. Then we have terms of contract. Terms of contracts can be express or implied. When we say express, those ones are listed expressly for parties to read in, especially in written contracts. The implied ones are those that by virtue of the express, even though they are not there, but by virtue of the contract, even though they are not listed expressly, but by nature and by nature of the contract they are entering, even though it's not expressly stated, it is expected that it will be one of the terms of the contract. A best example is definitely if you are selling a car to a person, the car must be moved from one place to another. So let's say you sold a car and the car is not moving, even though it's not expressly stated in your agreement that the car should move from point A to point B. There is this implied term that that car should move from a certain point to certain points. But hardly do courts want to imply terms to a contract because there are plethora of authorities that says it is not the duty of the court to impute terms for parties in their contract. The court will interpret the contract the way it is. So it is advisable for parties, if especially when you are entering into a written contract, to state all the terms expressly for everyone to see, so that if the court wants to interpret your contract, the court will not be dilly dangling, looking for a way to imply certain terms. But where it will occasion injustice, the court will have no choice but to imply certain terms. Then what are those elements that are likely to vitiate a contract? What are those elements that are likely to invalidate a contract? Yes, there are some contracts, all these elements of contract we listed earlier might be present, but once somebody enters into the contract compulsorily under duress, especially using physical threat on that person, such contracts will be vitiated. Undue influence is when you have an influence over somebody and you use that influence to induce that person to enter into a contract. In such a case, such contracts will be vitiated. The influence could be you have a fiduciary relationship, a special relationship with that person, and sometimes this undue influence can be in the absence of a relationship with that person. Maybe you have a knowledge of something that person has done, and or his colleague has done or his family member has done, and you are using the knowledge of what you have to influence him to enter into a particular contract. Such a contract are vitiated by virtue of, of such acts. Then misrepresentation is another thing that can vitiate a contract. When you misrepresent facts about certain things, about a commodity, about a house, about a car, when you misrepresent facts before or at the time of entering the contract, as such contracts will be vitiated. They will not be valid because you misrepresented facts, and it's based on that misrepresentation, or it's based on that fact you misrepresented you misrepresented to person that led the person to enter into contract. In such a case, such contract will be vitiated. Then mistake occurs. Mistake too is another element that can vitiate a contract, where the subject matter of the contract is no longer in existence. Let's say it's a filling station that Mr. Johnson and Mr. John are negotiating on. Mr. John wants to buy the filling station at Gogolada. The filling station is located at Gogolada. Not knowing that at the time Mr. John was making payments, at the time of negotiation, the filling station was burned down. So at that particular time, it was unknown to parties that the subject matter of the contract, which is the filling station, is no longer in existence. So in such a case, that contract is rescinded by virtue of the subject of contract not in existence. Then we have mutual mistake too is another thing that can vitiate a contract, whereby for instance, Mr. Johnson owns a Mercedes and a BMW car and is offering the two cars, the Mercedes for 50,000, the BM for 40,000. But Mr. Johnson thought that Mr. John is offering the two cars for 50,000 naira. and he went ahead and paid 50,000 naira for 2 cars. In such a case, there is a mutual mistake, and such can vitiate a contract. So then, what are those things? How can a contract be discharged? A contract can be discharged once parties have performed their obligations under the contract. Is it supply of rice? You've supplied the rice and they've paid you your money. You've performed your obligation under the contract. The contract is discharged. Frustration is when the subject matter of the contract is no longer in existence. When I remember the example of filling station I just used now, the filling station is no longer in existence. So parties will be discharged by frustration, because there's the subject matter that was initially bringing parties to the table of negotiations is no longer in existence. When there is a fundamental breach of the terms of the contract, you order from Jumia an iPhone and they supplied you HTC. That's a fundamental breach because you requested for an iPhone, not HTC. Then, by virtue of mutual agreement, parties by virtue of mutual agreement can agree to end a contract. So the contract will end between parties. Then, what are the remedies? Remedies for breach of contracts. So this is the final topic we are going to look at for today. Uh, Final subtopic under law of contract, and we are done. Damages and monetary compensations that are paid to individuals that might have suffered as a result of a breach of contract. So it's just monetary compensation. If you're a lawyer, or you've gone to court before, or you've had a court case, you know that damages can be general, can be specific. So we are not really interested in that in this class. Then we have specific performance or part performance. Part performance or specific performance is when you approach the court and you approach court and says court should mandate the other party. You have performed your own part of the contract. Is it supply of rice? You supplied the rice, but he is yet to pay you. Court will say you can approach court and say they should mandate Mr. So to pay your money for the supply of rice you've offered to him. So this is specific performance. Is one of the remedy available. But specific performance is not always granted by court, except where damages will not be sufficient. That is where uh, uh, specific performance will be granted by court, and specific performance is granted especially where it comes to issues of land. That's where specific performance is mostly granted by courts. Then we have ratification. Ratification is the court altering the terms of the contract. Maybe he's to supply he has supplied, instead of supplying 50 bags, he supplied 20. You supplied 20 bags to someone, and him he's saying, okay, because you supplied 20 bags instead of 50 bags, he is not going to pay your money. You can approach the court. The terms of the contract can be ratified, and the court will ask him to pay you for that 20 bags you supplied instead of the 50 bags. So they've altered the uh, terms of the contract. Then we have what we call injunction. Injunction is just restraining a party from doing something. They're asking the court to restrain another person from doing something. But injunction, you see, can be, depending on the circumstances of the case, it can be mandatory injunction. Sometimes it can be you asking the court to make somebody to do something. So that's why I said injunction can be mandatory depending on the circumstances of the case. Then we have what we call the quantum merit. Quantum merit is just you approaching the court saying that you've performed your responsibility or your obligation to a certain level. So as a result of that, you are entitled to payment for that which you've done to that certain level. For instance, you are constructing a house for somebody, you've reached a certain level, then the person is not a fault of yours. It's not as a result of anything you've done. The person just said you should pack up and leave his side. So you can approach the court and say, okay, for this level of work that I've done to this person, I expect him to pay me for this reasonable of service that I've offered to him. That is you are requesting for quantum merit. Then we have rescission. Rescission is when the court rescinds the contract totally. That means the court is saying the contract is no longer there is no longer contracts between parties. So both parties are discharged from their obligations. So thank you very much. We've come to the end of today's class. So if you have any question, observation, or anything, any question, observation, recommendation you want to do, now is the time to do that. You can ask your questions. If you have any question, now is the time. If you have any question, observation, or recommendation, now is the time to make such. Questions, recommendation. We've discussed a lot of things. So if you have any, because of the discussion, if there's
Yes,
anything
we on the way. I'm coming.
if there's anything you don't understand or you want
I'm
to,
still. Don't worry. I'm on my way. Don't worry.
no, you just talk. It's not like you. Hello? Mr. Mubarak, it seems like you want to ask a question.
Yes, yes. I want to say something. Good day. Can you hear me? Hello. Can you hear me? Hello. I can't hear you. No one is hearing me. Hello. Hello. I'm lost.
I can hear you.
I can't. Okay, okay. I have a question, please.
Okay, sir.
The question the question I have here is this. Regarding to this process of application of this loan, I understand we are encouraged to register a business name, but I want
Yes,
to
sir.
ask if in future I might decide to make my establishment or my company a multinational one or a bigger company instead of being a sole proprietorship, and I still have intentions to retain the name. What are the implications? Please, I want to understand that because I want to know if I'm still going to maintain my name because I registered it with a sole proprietorship under the CAC, or will I have to make some adjustments while trying to incorporate it in business? A partnership or a company growth.
Okay. Once you register a name with the CAC, let's say a business name, you've registered it with the CAC,
Yes.
and eventually you want to upgrade it to a company, you can still make use of that name you registered with initially. There are provisions, there's a way you go about doing that, where you upgrade it from a business name to a company, a private limited company, and eventually you've upgraded it to a private limited company, and you want to upgrade it to a public limited company, you can still do that using the same name. So there's a provision for that. So the fact that you began with a business name does not mean you cannot upgrade it to become a company or anything. CAC has a provision for doing that. Thank you.
All right. Welcome. Thank you, sir. I appreciate it.
You're welcome. Okay, in the absence of any questions and contribution, I will hand you to our program coordinator, Dr. Oguche, for the closing remarks. Okay, he will soon be with us. He will just give you a closing remark on what he expects of you from today, being the last class. This is the last class we're having today, the last module. So from today we're done. So the program manager will inform you on graduation and how you are to get your certificates. The rest.
Yeah, good afternoon, ladies and gentlemen. Let's show our appreciation once more to Barrister Johanna for the wonderful presentation he just made for us on business law, business registration and compliance requirements. I hope that has been able to assist substantially for those who want to register their companies going forward. And then, of course, laying the background to what you expect if you want to do or run business in Nigeria. It's especially important for those of you who are going into business to be very, very familiar with all the issues that you discussed this morning. So join me in thanking Barrister Folmi Johanna for this wonderful presentation. Yeah, as he indicated, this is our last day with you. So I want to thank you immensely for spending the week with us. Those of you who have been able to be very consistent in the class to the very end today. Yeah, what we normally do on Saturdays, the classes end today, but Saturdays we have our little ceremonies. We'll have our graduation ceremony tomorrow. It's also a virtual ceremony. It's nothing physical. And we'll not also be on the Zoom platform as we are today. It will be purely on the WhatsApp platform, where we'll be sending you some graduation speeches. And after that, from around 12, by 1, we'll send in the final graduation speech, and then we'll start to distribute your certificates. Everybody will get his own certificate tomorrow. It will be posted to your WhatsApp account. So you will help us to check to make sure that everything is correct, correctly written. On the certificate, you will see the code. That is the code that you are asked to complete on the form, the loan application form, which we discussed yesterday. Secondly, all of these forms will be expected to download. We're not going to send you hard copies. You will have to download it, just like some of you downloaded the forms, and then you print and keep for as your own copy. And then tomorrow also we'll throw the platform open for those who want to exhibit any of their products. Those of you who are already in business or enterprises who have things they want to exhibit on the platform, will have the opportunity to do exactly that, so that you have the opportunity of you and your colleagues on this program marketing and helping yourself to sell and market your products. Because when you are involved already in some kind of productive activity, anybody who sees what you're already doing and finds it interesting will also pass the word for you. So that's why we provide an opportunity, and that platform will be open until Monday, when we shut it for that purpose. But the entire platform, the Batch 23 platform, will be open for us to continue to engage with you until all of you are successful with respect to the loan application. That is when we eventually begin to the process of winding down the platform. All right, having said that, let me thank you once again for being here with us today, and to pray that going forward, your applications will come through and then you will all be successful And then as you succeed in your new entrepreneurial enterprises, that will also be a credit to us, I'm sure, because our name will also always be mentioned where you are mentioned as having successfully started a business and become as a big corporation further down the line. We will want to also share in your success. Then, of course, be part of taking the credit for nurturing you to be where you are today. Right. So on this note, let me close this training session formally, and then to wish you all the very best going forward. Thank you very much, and have a wonderful day ahead of you, a wonderful season ahead of you. Merry Christmas and a Happy New Year ahead. Thank you.